Today, we took a look at the court's order regarding the defense of third-party culprit and regarding the defense's proposed expert regarding police procedure, which will also go to one of their defenses, what in Massachusetts they call a Bowden defense. The Bowden defense roughly encompasses law enforcement didn't investigate things they should have investigated, didn't follow proper procedures, and allows an instruction to be given regarding the police investigation. The court denied the motion for that expert and pointed out in her order that she had not seen another case in Massachusetts where that type of expert had been used, which is incredibly unusual to me because this is really frequent in other jurisdictions. It was strange to me at the hearing over this motion in limine when the court said, I've never had a case where anyone's done that. I've not seen that done, because it is such normal procedure elsewhere to bring in an expert in policing and say, this is normal policy and procedure. This is how police do a chain of custody, and then juxtapose it to what was done in a case. The court cited a lot of case law that said that this is done through cross-examination and is allowing the defense to do that through cross-examination, but not through their own expert, saying that that's not what's done in the jurisdiction. If that is an inaccurate statement of the position of the law by the court, then it'll come up if Karen Reed is convicted on appeal. But as we are getting into jury selection on April 1st, the court needed to get these rulings done and out, and we'll see. Who knows? Could the door still be opened and the defense still argue they should get that expert? They can try, but when it comes to bringing in an expert, it's going to be a bit harder, but the discovery's all been turned over. So we might see further argument on that depending on how the evidence comes in. And the court denied the defense third-party culprit motion with regard to Colin Albert, allowed it with regard to Brian Albert and Brian Higgins, much in the way she allowed it in the first trial, which is if the defense establishes the threshold evidence, then they can argue third-party culprit and ask for the third-party culprit jury instruction. And the court noted in a footnote that the defense did not ask for that instruction in the first trial. The court had some pretty strong language for how the evidence came in her order. We've seen that in a couple of her orders, but it was very strong language for how she felt about the third-party culprit defense, pointing out repeatedly that it needs to be beyond mere or rank speculation, that there needs to be evidence established to provide it, and will not allow the defense to go down that road with regard to Colin Albert. The court also pointed out in that nothing in that order will forestall the Bowden defense, and part of the Bowden defense can be these individuals should have been questioned more. These individuals should have been looked at by police more. Their behavior was this. The investigation was this. So it doesn't close a door on the Bowden defense. It requires the defense to meet the threshold to bring in that third-party culprit with regard to Brian Albert and Brian Higgins, the way that the court ruled during the first trial. We will see if the defense tries to open that door, or if they try to establish that evidence as impeachment and as evidence that these individuals should have been investigated more. That's different than saying one of these individuals did it. This is the person that did it. I think it's an easier argument for the defense to say, look at some of these individuals, look at their behavior, and they were never investigated. I think the Bowden defense is the stronger defense. The defense, though, gets to choose what they want. They can choose to bring a third-party culprit. I do not think it's their strongest argument, but they have to meet that threshold first before they get a jury instruction on it. We will see how that all plays out. Again, the court has ruled that it can't come up in opening statements because that threshold won't have been met yet because evidence hasn't come in. And we saw the defense staying away from that in opening statements last time, really going into the police investigation and opening, not into this third party is the one who did it. That is the differentiation between that Bowden defense about law enforcement and the third party culprit accusing someone else of committing the crime versus it just wasn't investigated and should have been. But that door seems to be closed with regard to Colin Albert. I don't know if we'll see the defense asking for that to be reconsidered as we get into trial, but they can ask for that to be reconsidered. And I expect we will see other rulings and motions continue to play out as we get into jury selection. The court has indicated to the jurors that this is about a 6 to 8 week trial on the outside end of it. And the court has said previously, and I don't disagree, that this jury selection might take 3 weeks. And the court was really looking at the end of April for opening statements in this case, but was giving time for the First Circuit to rule. Well, they've already ruled. They denied the habeas petition again, or technically they affirmed the denial of the habeas petition. So this case is full steam ahead. It's going to take time to pick a jury, and it's going to be day by day of individual voir dire, and quite a lot of people who've heard about the case, quite a lot of people that have already made up their mind about this case. After a trial, it is hard to keep an open mind if you know about this case. It is going to be something that I will be working on. I'm sure it is something the law nerds will be working on, is new case, new information, and I will try to keep an open mind. But the questions I had from the first trial that are still not answered become a bit more ingrained in your brain when they are still lingering going into a second trial. I'm interested to see what witnesses get called and don't vis-a-vis the first trial. I'm interested to see if the opening statements change or the tenor of those change. And of course, we have a whole new prosecutor on this case. And by the looks of it, we're going to see that prosecutor do just about everything. And I'm interested to see what a Brennan opening statement looks like in this case. So when will we get to opening statements? Probably the end of April. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.